Thank you. Thank you, Lori. I'm going to start. My name is Karina Flores. My pronouns are she and her. And as Lori said, I work in West Central Women's Resource Center. I'm the Director of Community Development, but I have had here in the center different positions that make me understand better, how to navigate systems and how to face difficult issues like it is gender-based violence. Um, when I introduce myself about these kind of topics, I like to talk a little bit about me as woman, I come from Mexico City. I was raised there, and unfortunately, I had to live there all kind of experiences of gender-based violence. So when I came here to Canada, I was hopeful to do the best. And unfortunately, I realized that there is no paradise for women. We all have to face difficult experiences, doesn't matter where we are. And in my family, I have to experience violence with my ex-partner. The immigration was a very difficult process. And parenting for me was a big challenge because I understood that there is no good and bad in this. It's just that the structure, the social structure, the systems, and the way as we understand and we live our gender make very complicated for us to have healthy relationships. So when I was here in Canada, I really feel very, very alone as immigrant. And thanks to some social networks that I was able to build and lots of women that I found in my way, I was able to recover and find resources, for me and my daughter to face the difficulties. So when I started working in West Central, a big part of my interest was to share what I have learned and to support other women and gender diverse people that I knew they were facing similar situations. I started working first as settlement worker, and later I took the position as gender-based violence case worker, and finally I took this position as director of community development. And in West Central, I have found a great place to work because the work that we do makes lots of meaning for me as human beings. In the center, you will find different kind of supports that includes in general wraparound services. We have different kind of programs that go from drop-in services where you can find safe space just to chat and drink a coffee or take some programming like eating or watch a movie or take a shower if you need or bring your laundry and get some emergency food. Or you can find lots of resources there, If you are facing a hard situation and you don't know where to ask, you can come to the center, chat with one of our case workers in the front, and they will be happy to try to guide you to other organizations, or if we have the resources inside our organization, they will refer you to the proper worker. We have programs too, like emergency housing programs. We have family supports that in cases where we experience gender-based violence in our family are very important because unfortunately in lots of these cases, CFS could be involved. So we have a family support worker that could guide you, if needed. When we are facing gender-based violence too, it's very important to know we will find a safe place where to stay. So our organization has supports for emergency housing, and we can do referrals if needed to other more specific agencies. For example, in cases that women are immigrant, we can refer to other organizations that support housing too. And in general, in the center, we can say that we have two big areas, or two big programs that cover everything related about gender-based violence. One of these programs is called Straightening the Circle, that it is directed to all women and gender diverse people and provides wide range of services like casework, in cultural appropriate services, and counseling if needed. And we have another program that it is just focused for the immigrants. About this program, Joe is going to talk more. Why we decided to divide the programs in this way? Well, because even we have common things always when we are talking about gender-based violence, there are few differences too. So to try to cover as much as possible the needs of our participants, we decide to divide the programs in this way. In the center this year is very happy in general because we are starting a new program that it is a second stage housing project. So the center will open a building with 16 units that, and in coordination with other emergency women shelters, we are gonna offer a safe place for women, gender diverse people and their families for up to 2 years, so they can find all the resources to rebuild their lives and to start over after they are experiencing a hard situation like could be gender-based violence in general. And as Lori said, our center tried to make our services as much accessible as possible. So please feel free to come to visit us, to talk with us. We are just human beings, we have experiences too about this kind of issues, and we are always willing to take some time and listen to your stories and find the resources that are appropriate for you. Joa is going to talk a little bit more about the services that are specific for immigrants. And Lori is going to leave the information here. So please feel free to reach us, to send us an email, give us a call if you need more information. Thank you.
Thanks, Karina. And thank you, Lori, for your introduction earlier and for having us today. Karina has really covered a lot of information about our center, took the words right out of my mouth, but I can speak more to my direct service provision with working with community. So if you were somebody who was going to come to see me, some of the primary things that we would do would be a risk assessment. I would listen, talk about what are some of the concerns that you have. We would do some safety planning, and then together we would map some of the resources that are available in community, see the things that are relevant to your case. Maybe you need support by accessing legal services, or you need to navigate those services. I'm not somebody that knows everything about every resource in the community, but my work is to walk alongside people once they come to see me. So we learn together, and we learn about the resources that are available. Each case is a little bit different, whether somebody is legally married or there are children involved, depending on the status that they have in the country. Fortunately, we were able to provide interpretation services as well, because it's very important for people to have access to services in their language and to ensure that they have all the information necessary for them to practice informed consent. So once we start working together, we follow up with an action plan, and then together we manage the case to see what needs follow-up. So if you need to start meeting with a lawyer, for example, and you need an interpreter, I can come with you and I can provide that interpreter. Again, every case is a little bit different. So a lot of the work is truly just doing a lot of research and investigation about what the possibilities are. And that's kind of a beautiful thing about it that I really enjoy, is that every time that you do something new with somebody, you learn something about a field that you might not have thought to look into, whether it be with a bank, housing supports, sister agencies. You end up making a lot of really great connections. So if you or somebody you know needs this information, you can go to our website, share that information with them. If you have any questions, you're free to send me an email, or you can give me a phone call at my office number. My extension is 220. And yeah, thank you everybody for coming, and I really look forward to Ria's presentation.
Hi, everybody. So yes, I am here to talk about family law and intimate partner violence. It is a very broad topic. I've tried to talk mostly about the process through litigation because that's what I've been asked to talk about. So I'm not focusing very much today on earlier stages or negotiation and settlement, but I am looking at what happens once your file's in the court system and going through the court process. If there are questions, I will do my best to answer as many of them as possible at the end. If there's any urgent questions, you can share them, and I may be able to answer them during the presentation as well. So as you can see, there is a fairly heavy agenda. There's a lot of things to kind of go through. The first thing that we're going to try to understand is what is domestic violence, at least in terms of the way the court system views it and how it defines it. And then we're going to look at the legislation that sort of shapes the court's decision making. We're going to look at 3 cases. 2 of them are my cases. So both Walsh and Hassler are cases that I litigated here in Brandon. And the Berenjet decision is from our Supreme Court, so the highest court in Canada. We're going to talk about the type of evidence and how that evidence should be presented to get the best possible results, and how to deal with issues of credibility and also some financial considerations. So that's broadly the agenda, but it is a very dense topic. So a lot of the areas we're going to just touch a bit of the surface of. Oh, okay. Is that helping a little bit with the mic? Yes. So we're going to provide a brief overview of the problem of family law cases involving domestic violence. And I'm going to provide some tips and tricks regarding admissible and inadmissible evidence, best methods of preparing and presenting the evidence, methods of cross-examination regarding credibility. So when we talk about evidence, one of the problems that I always see in these cases is people wanting to provide evidence of hearsay or information that they don't have objective evidence of. So that's one of the things we're going to talk about when we talk about evidence. And of course, credibility is almost always a significant problem in these cases. And so we're going to talk about how best to ensure credibility in your evidence. I will talk a little bit of the risk of raising allegations of intimate partner violence and common defenses. And so in all of the cases I've done, I see almost always the same defense. The most common defense is, I may be violent, but she is too, or I may be violent, but they made me violent. So those are the most common defenses that we see. Of course, the other one is, I'm not violent at all. That's less often raised. More often than not, it is the idea that it's mutual violence. I will talk a little bit about the trends in the case law and the amendments. So the case law is changing. It has been changing the last few years pretty dramatically, especially with the Supreme Court decision and Berenjet. So there are some trends that have opened up a little bit more avenues for domestic violence cases, and we'll talk about that. There are remedies underneath lots of different legislation. So we're going to talk about some remedies in the Domestic Violence and Stalking Act, as well as remedies under other legislations. We're also going to talk about the challenges that exist even after court orders are made granting relief or not granting relief. So one of the challenges, of course, is that no matter what a court order grants or doesn't grant, it doesn't necessarily make your reality of parenting with that person better, and it doesn't necessarily always create the safety that you might hope for. So we have to, if you're successful, even if you win everything you could ask for, it doesn't necessarily mean that you're going to have a perfect experience going forward. We will talk about how intimate partner violence affects negotiations and out-of-court resolutions. I won't talk very much about that just because there's so much density with the case law and going through the litigation process, but I will touch on it a little bit because I do think it's important. And I will touch a little bit on how it affects financial settlements, including child, spousal support, and division of property. So in general, my experience has been that when there are issues of domestic violence, it almost always impacts financial settlements, including child support and spousal support. So whether those are being paid or being refusals to pay those things, and it almost always affects division of property. So whether there is a willingness to share financial disclosure and things of that nature. So we'll talk a little bit about that as well. So when we look at the legislation, so I've provided you with the specific sections of the legislation that define what domestic violence is. So the first thing is that you have to be in an intimate relationship with the person or had a family relationship with the person. So that could mean it could be brothers, it could be sisters, mothers, sons, all of those kinds of things. But for the most part, what they're looking at is a conjugal relationship where you've cohabited in an intimate way. Otherwise, you don't fall under the legislation. So it's just important to understand that you have to have lived together or cohabited in a significant way to fall under the legislation. When you look at the legislation, it is broad. So it includes, and I always highlight that it includes psychological and emotional abuse, sexual abuse, and financial abuse are all included in the legislation. So I think it's really important to note how broad it is and that it can include intentional or reckless conduct. It can include threats and things of that nature. When we get into the case law, we'll talk about how the court tends to view domestic violence, though, in reality, and what happens when the abuse is more of psychological or emotional abuse. So certainly those are included, and it's included in the legislation in the Domestic Violence and Stalking Act, but also in the Family Law Act and other legislation as we go through. And it is important not to minimize those aspects as well. So when we look at the Family Law Act and the Divorce Act, so the Family Law Act was very recently amended. So this is new legislation for us. So in other provinces like British Columbia, they have had family violence in their legislation for much longer than we have. But in Manitoba, it is relatively new to see this. So this has been in place for a little less than a year, I believe. And the Divorce Act also amended their legislation just before we did. And so again, it includes physical abuse, but it also includes psychological abuse, and they specifically say financial abuse or threats to kill or harm an animal or damage property. So again, it's a very broad definition that you're seeing here, and it is trying to encapsulate any sort of violence that you might experience. It's not, I think it traditionally in the old view, we think of domestic violence as bruises or damages to yourself that you can see. But the legislation is really trying to encapsulate that it's intangible violence as well. So violence that you can't necessarily see on somebody's body or in somebody's property. So the legislation sets it out. It does include all of those factors, and it's important to note that those are all factors for the court to consider. So I note that it's vague. So I say it's vague because the legislation doesn't necessarily give you good examples of what might constitute psychological violence, and it doesn't give you good examples of what might constitute financial violence. So this means that it really does stand up to how a judge interprets the evidence that's in front of them. They use something called the reasonable person standard, which is essentially to mean if I was in that situation, subjectively, it doesn't matter if you're afraid, it matters if objectively a judge decides that would be something that would cause a reasonable person to have fear. So it is a subjective interpretation by the judge, and it's important to understand, and as we get into the cases, you'll see that judges interpret the evidence differently depending on a variety of factors. And so We always have to keep in mind that when you get into a courtroom, you're leaving your fate up to a single person, and that person may view your evidence in an unfavorable way, no matter what you do to put your case together. I often find that it's very difficult to convey violence to a third party who's not experienced it or witnessed it. So cases where I've been most successful have been where the violent party acts out violently in court. And so you'll see that in Berenjet, for instance, which we'll talk about later on. The husband in that case exhibited demeaning and he exhibited behavior towards the wife in court that led the judge to conclude that he was engaging in domestic violence. So it is important. Sometimes that's the best evidence, is letting the judge see the person for what they are. But a lot of people who engage in domestic violence are very good at maintaining composure in those kinds of circumstances. I would also say that one of the things that a court considers is it bad enough for a remedy? So again, a judge may hear your story, may agree that there is violence, may agree that that violence is problematic, but may not think that they need to do anything to fix that violence. Those are some of the most difficult outcomes. When you put your whole case together and you lay it all out for the judge agrees with you, but then says, what do you want me to do about it? So that's one of the realities of the limitations of the court system. And so that's what we're going to talk about as we talk about some of the cases. Every case is very fact specific and interpreted differently by each trier of fact. And so that's one of the challenges, is that there are a variety of judges. In Manitoba, I think there are 40 family court judges in Winnipeg. There's only 3 here in Brandon. But there are a variety of different people who might hear your case, and each one of them comes with their own history and beliefs about violence. So how one judge might interpret your facts and how another might interpret your facts might be different. Finally, judges, again, they look at the lawyer and they look at the parties and they say, what do you want me to do about it? And that's one of the challenges that we always end up with, is how should a court remedy domestic violence, even if we can prove it, which is always a task in of itself. Once you prove it, then what? So that's what we're going to talk about today. So the legislation, again, it's trying to recognize that this problem is significant and that this problem has a significant impact on children and parties within the system. So the legislation has directed the court to minimize conflict and protect children and parties from violence. Again, it says this, but in practice, how does that operate? That's the question that we all need to see, especially as this legislation is relatively new. The legislation requires the court to consider family violence and determine the best interests of children. So this is the first time we see this specifically in the legislation. It had always been in the background, but it had never been written out in clear language like this, that family violence must be considered. So one of the things the court is going to consider is the ability and willingness of any person to care for and meet the needs of the child, the appropriateness of making an order that would require persons in respect of whom the order would apply to cooperate on matters affecting the child, any civil or criminal proceeding, other conditions or measure that's relevant to the safety, security, and well-being of a child. So what they're really looking at is the violence so bad that these parents can't communicate? In which case, do we need to think about decision-making? Do we need to think about how exchanges happen? Is the violence so bad that the child might be harmed themselves? Those are all things that the judge is going to consider. If you can't correlate the violence to an order that the court needs to make, the court's not going to make an order. So you have to be able to link the violence to a specific remedy that you need and why the evidence supports that outcome. We can go to the next slide. So the factors relating to family violence and what the court's going to take into account This is where this is extremely discretionary. So it's important to understand that although there are appeals and other things that you can do, the judge who hears your case is the most likely to be, their decision is most likely going to be upheld because almost everything is discretionary. So when you look at the nature, seriousness, and frequency of the family violence and when it occurred, so essentially, is this a single incident that occurred? Is this an ongoing occurrence? Is this something that the court needs to still be concerned about affecting the children and parenting? Is there a pattern of coercive and controlling behavior in relation to a family member? So again, this is one of the first times we've seen the word coercive and controlling behavior in the legislation. So this is exciting to practitioners that they're actually including this language, that they're recognizing that this is a real problem. Although again, in practice, how do you prove a pattern of coercive and controlling behavior? Again, that's what the trier of fact is there to determine. And that's where some of the challenges come in, is improving those patterns. Whether the family violence is directed towards the child or whether the child is directly or indirectly exposed to the family violence. So again, this is the first time that we're seeing exposure to family violence as a factor that the court's going to consider. Of course, if a child is abused, that's always been a factor that's been considered by the court. But the fact that they're now considering what the impact of exposure to family violence might be, that is a new direction for the court and something a little bit more broad. The physical, emotional, and psychological harm or risk of harm to the child. So when we look at the Supreme Court decision, Berenger, it talks about the effects that witnessing domestic violence has on children and the significant harm that children can come away with, even if they are not abused themselves. So the court is recognizing this, the legislation is starting to recognize this. But again, the question is, how do we prove it, firstly? And secondly, what is the remedy that we're seeking? Because even in cases of significant violence, the court doesn't usually say that there will be no contact at all. So almost always you're going to be in a situation where there will be some parenting for an emotionally abusive parent. The question is, how do we limit that harm and how do we keep children as safe as possible within that parenting relationship? Any compromise to the safety of the child or other family members. So again, this factor allows the court to consider things like exchanges. How are the children going to be exchanged? Whether one parent is going to know the contact information of the other parent, the addresses of the other parent, and how to minimize any conflict at exchanges that might affect children. So those are all the factors courts are going to consider under that factor. Whether the family violence causes the child or other family member to fear for their own safety or for that of another person. So again, this is one of the first times we're seeing it spelled out this way. But this again focuses on a little bit on what the impact of parenting with a violent parent might look like. Any steps taken by the person engaging in the family violence to prevent further family violence from occurring and improve their ability to care for and meet the needs of the child. So generally speaking, this is going to be if the parent who's engaged in violence recognizes the violence that they've exhibited and starts to take things like counseling. So in Brandon, the John Howard Society is, is this going better? So in Brandon, the John Howard Society does a program about anger management. So that would be one good example. There is also a positive parenting course. And there is a building bridges course that is often taken by people who engage in domestic violence. One of the concerns that I've always had as a practitioner is whether the fact that someone's taken a course means that they've actually learned or benefited from the counseling that they've received. And one of the struggles that we have is sometimes people will have certificates or they will have done certain things, but the concerns that the other parent has about their parenting or their relationship with that parent have not really minimized or changed. But judges do put a lot of stock in somebody taking these courses and actively trying to improve their behaviors. So you can see that H says any other relevant factors. So again, this is discretionary. This lets a judge consider anything that they could possibly think of if they think it affects the case. So the door is completely open for a judge to consider absolutely anything that they deem necessary. So I just note that the Divorce Act mirrors the Family Law Act. So this is sort of technical in nature, but if you're married, you have to use the Divorce Act. And if you're not married, you have to use the Family Law Act. So it used to be that they didn't mirror each other. So the Divorce Act changed first, the Family Law Act changed second. And so it just affected whether we could raise certain things or not. But now the legislation mirrors each other. So whether you're married or not married, the same factors will be considered, and you'll be treated the same way whether you're married or common law. So Berenjet is the Supreme Court decision. So this is probably, in my view, this is the most significant decision that's come out from our Supreme Court with respect to family violence. When I read it, I was very happy that the Supreme Court had finally sort of acknowledged the issues and had made some very strongly worded comments that we could use in other cases. So the important thing to understand about the Supreme Court of Canada is that it's our highest court. What they say is binding on every court across Canada. So judges in Manitoba, judges in Alberta, judges in British Columbia, they're all bound by this decision and we all need to follow it. So that's why it's really important when the Supreme Court says something, that is the final word on something. So this case is involving a mother who wished to relocate approximately 10 hours away with the children. She alleged the father committed a single act of physical abuse. So there was a history of emotional and psychological abuse, but the only physical abuse that occurred was after separation. And I wouldn't call it the most significant. So I believe it was a shove. It wasn't, it wasn't an awful situation where she was hurt and there were police. It was not minimizing the violence, but it wasn't the most firework type violence that I've seen sometimes. So the Supreme Court looked at the impact of the violence on the relocation proposal and parenting plan, as well as provided some context to courts across Canada on how to consider the violence in the context of parenting. So the court says determining the best interests of the child is a heavy responsibility with profound impacts on children, families, and society. In many cases, the answer is difficult. The court must choose between competing and often compelling visions of how best to advance the needs and interests of the child. So the court's noting that this is not an easy task, even when you have all of the information in front of you, and even when you can credibly rely on that information. The question for the court is, what do we do with the information we have? So the court held that family violence is a significant factor impacting the best interests of children, and further holds that it is a highly contextual basis because of the multitude of factors that may impinge on the child's best interest. So the important thing I think to understand is that to some extent, what the Supreme Court is saying is that the judge, the trier of fact, the person who heard this case, was in the best position to make a decision about what was good for the child and for the mother in this case. So they overturned the appellate decision. And the reason for that was because they're saying it's highly contextual. The person that heard the evidence at first instance, they're the best person and they're the best suited person to make a decision. They also say, and this is sort of the quote that I highlight most often, it is highlighted in Hassler as well. The suggestion that domestic abuse or family violence has no impact on the children and has nothing to do with the perpetrator's parenting ability is untenable. Research indicates that children who are exposed to family violence are at risk of emotional and behavioral problems throughout their lives. So prior to Berenjet, we often saw conclusions from the court that although there might be violence, it doesn't affect their ability to parent the children. So that was the most often conclusion, that unless you could show the children themselves were being hurt or that they were being assaulted or emotionally abused, they weren't going to limit or change the parenting arrangements. So this quote, the suggestion that domestic abuse or family violence has no impact, this is a significant statement from our Supreme Court that all of our courts are supposed to take notice of. It also notes that domestic violence allegations are notoriously difficult to prove. Thus, proof of even one incident may raise safety concerns for the victim or may overlap with and enhance the significance of other factors, such as the need for limited contact or support. This is important. Again, I have not found, and I'll be frank, I've not found in practice that a single incident would be sufficient for the court to make the type of order that was made in Berenjet. I would also note that I don't believe that's why the judge made the order he made. When you read the decision, the judges again focused on the fact that in testimony, in the evidence in front of him, the father in this case was still exhibiting abusive behavior. His relationship with the mother had not improved, and his belittling and demeaning behavior was significant. And that went so far as during the trial, the father provided intimate images of the mother to the judge. Doesn't really tell me why he did that or what the purpose of that was, but the judge leaned on that as one of his reasons for thinking that the father was not going to stop engaging in the abuse. So I don't think this court ruled that because there was a single incidence of shoving that the mother should be able to move. But I do think it's important that this case really highlights the fact that it is very difficult to prove violence. So if you can show one significant incident, the court must take notice. And so I think that's important because a lot of the time people think, well, I don't have enough evidence, or it doesn't happen often enough. So this really does tell you that it doesn't have to happen every day or every other day for it to be important and for it to be a consideration that the court must consider. The court also says that it's going to be an important factor in mobility cases. And so that's important because, again, one of the things that they were considering, you can go forward or back, it doesn't necessarily make too much difference, but they must consider family violence. And because it may be a reason for relocation, it's an important factor in mobility cases. Oftentimes, people are looking to relocate to be closer to supports, to be closer to family so they don't feel as isolated. That's an important factor to consider. In Berenjet, that was her reason for wanting to move. Her family was all 10 hours away, and she felt extremely isolated and unable to cope co-parenting with somebody who was demeaning in nature towards her constantly. So that is an important factor, and it will be a factor that courts will consider. So it is important to note that this case made it to the Supreme Court, which is very, very, very rare. So most often cases are heard by a single judge, and that decision is going to be upheld and binding. The Supreme Court gets a lot of applications to be heard, and they almost always reject them. So it is extremely rare that a case would make it to the Supreme Court. What this means is that our court wanted to make some comments with respect to domestic violence and with respect to mobility cases. But it is very, very rare. It's also important to know that the Court of Appeal, so the legal process involves, firstly, you have a single judge model. So in first instance, your case is heard by a single judge. If you disagree with the decision that single judge made, then you can appeal. And when you appeal, it goes to a 3-person panel. Okay. In Manitoba, that's the Court of Appeal. In Winnipeg, 3 judges will hear your case, and they will decide whether they're going to uphold the judge's decision or whether they're going to vary it for some specific reason. Appellate courts should only interfere if the judge made a mistake in the law, so they can correct any errors that a judge made with respect to the law, or they can correct any palpable and overriding errors. That means the judge has to be so wrong that it's obvious on his face that the judge made a mistake. That is a very, very, very high bar. And that's why what I say to you is most often what the first judge that hears your case says, that's what's going to rule the day. But in this case, the Court of Appeal reversed the trial judge and said specifically that the violent behavior of Mr. I don't know how to say his name, so the father warranted some context, and then they go on to provide that context. And so what our appellate court said is that there are 4 factors that reduce the seriousness of the circumstances. First, the mother never argued that the hostility between the parties supported her move. Second, mother's evidence when the parties were getting along better than when they first separated. So the court was saying things were improving. Third, there was no evidence of any events involving or taking place in the presence of the children since separation. And 4, the parties' relationship was improving. So I highlight the fact that the Court of Appeal reversed the trial judge's decision because it's important to note how different decision makers approach family violence, and to note that the view that violence is not so significant or so ongoing to warrant court intervention is prevalent. So when an appellate court makes that decision, I take notice, because what that means is that a panel of 3 judges, made that finding that the violence wasn't so bad, and that they would not have allowed the move. So I would argue it's always a risk as to how the judge will interpret the impact of the violence and what, if anything, a court should do about it. So the appellate court wasn't going to do anything about it. They didn't think there was any need for court intervention. They didn't think the mother should have been able to move, and they disagreed with the trial judge. Thankfully, our Supreme Court did interfere, and they did uphold that trial judge's initial decision. But I do highlight that to say, anytime you raise family violence, it's a risk, and you never know how a judge is going to interpret it. So that brings us to Walsh and Walsh. So this was my case. This does predate the Baron-Jett decision. The Baron-Jett decision came out right after this case was litigated. Actually, it came out before this case. This case did go to our Court of Appeal, and it was rejected by our Court of Appeal. And so what I took to the Court of Appeal was specifically the finding of the trial judge. And I've put the quote here: although I'm satisfied that the behavior described fits the definition of domestic violence, I'm not satisfied that it is one way. Both parties show little empathy towards the other. The respondent does not answer the petitioner in a timely fashion when she asks about activities. He is often abusive in his communication with her when frustrated. This must change. On the other hand, upon separation, the petitioner severely restricted the respondent's time with the children. She claims to have done so in the best interests of the children. The evidence satisfies me that this denial of time with the children was a considerable source of frustration for the respondent. The petitioner shows no understanding of why he would have been frustrated at being denied meaningful time with his children. So the trial judge granted no remedies to the wife to remedy the family violence, finding essentially both parents are violent to each other, and therefore no remedy was necessary. So it's always important to understand that this is one of the most common defenses that I see. So in this case, the husband suggested that the reason he called his wife names, and those names were very offensive, and they were continuous all through the separation and ongoing. The court decided that the reason he did that was somehow the wife's responsibility because she caused him frustration. So that was the issue that I really took to the Court of Appeal, was the finding that a considerable source of frustration would somehow warrant the responses from the husband, and also the impact that would have on the children. So I think it's important to understand that the remedies we were looking for in this particular case was decision-making authority, and the ability to limit communication so that the wife would have the ability to enroll the children in activities without needing to speak to the husband. We weren't asking to limit his parenting time. We recognized that we wouldn't likely be successful in that, and so we focused only on trying to limit the wife's exposure to the violence by limiting her interactions with the husband. Because the judge believed that both of them were the cause of the violence, he didn't provide any remedy for that issue. So So that's one example of where you have to be careful of what a judge is going to do with the information. So Hassler and Hassler is also my decision. That is a more recent decision. It does come out after the Berenjet decision. It's the same trial judge. And so I think that's very important to note is that the judge that made the Walsh decision is the judge that made the Hassler decision, and he decided very differently. So he firstly found that the mother's allegations of violence were credible and reliable. He did cite the Supreme Court decision, Berenjet, and he noted that the court must consider family violence. He made a finding that the father relies on decision-making disputes to exercise control over the mother and grants decision-making authority. So this is what we were looking for in Walsh that we did not get. So in this particular case, and I think this is where the rubber hits the road, is you need to be able to prove that there is a dispute in decision-making that's being exercised unreasonably and to cause control or to exhibit abuse. And so that was the finding that the trial judge made here, and it was important. I would also note that in Hassler, we did have an expert report. And so we had a report from a social worker who came in, and the social worker recommended that father's parenting time be limited with no expansion for holidays or other periods. And the report specifically noted that because of the father's temper and likelihood to have frustration, that he shouldn't have more than a couple of days in a row with the children. And so again, I would note that this is not a situation where the father did not get parenting time. He has parenting time on alternating weekends from Friday until Sunday. He just wasn't allowed to have many more days than that. And again, that was because of the violence. So when we look at what's different in Hassler from Walsh, Hassler involved voluminous evidence. So in Walsh, predominantly the wife testified and told the court about the violence. In Hassler, we provided pictures, dozens and dozens and dozens of pictures of bruises, of broken property, of text messages that involved threats and abusive language, and calendars that showed different things, including how often he showed up for parenting time and all of that kind of thing. The other thing that we provided was evidence from third parties. So I did not provide that in Walsh, but I did in Hassler. And so in that case, Ms. Hassler's mother testified to a very significant incidence of violence that she observed. And that incidence of violence involved the child. So it involved the father breaking lots of the household contents in front of sort of an infant child because he was overwhelmed with her crying. So those sorts of evidences from the third parties, and I think the pictures and text messages really solidified the court's ability to make a finding that the wife's evidence was credible and reliable. That's problematic to me because most of the time people don't have that kind of evidence. Most of the time when you're experiencing family violence, you're not taking a picture, you're not writing down on your calendar, you're not taking notes. Ms. Hassler was an unusual victim, so to speak, in the sense that she did document things. She was very careful about documenting things during the relationship and after the relationship, but that's not evidence that we usually have available to us. I always say to my clients that their story is evidence and it is impactful. That being said, judges like to hang their hats on some of these objective things that they can look at, things that they can see, things that are tangible for them. The other thing that the court really looked at was that the husband in this case did not convincingly deny the behaviors, and he often pretended that he couldn't remember as opposed to denying. So most often the husband would respond, "I don't remember," rather than "that didn't happen." So that was one of the things the court relied on. So that leads us to the question of evidence. So hearsay is usually inadmissible. So A lot of times the clients will tell me about what the daycare told them, what the school told them, what places observed. So the kids came from dad's house and they didn't have their jackets on, they didn't have their shoes. Dad yelled at the teacher. You can't bring that kind of evidence. You have to either provide the teacher to say that dad yelled, or you can't submit the evidence. And so that's one of the challenges that always exists, is we don't want to bring in every person you've ever met to testify about the violence. But also, if you want to lead evidence, you really have to be careful that you're leading it from the party who experienced it. The most often that we hear hearsay, though, is what children tell a parent occurred while at the other parent's home. That's not going to be considered by a trial judge unless it's verified by some third party. So a lot of times my clients will say that when the kids come home, they told the mother about an incident where, dad punched a hole in the wall, or dad broke something, or dad gave them a spanking, or put them on a timeout that was for hours. I can see a question here. Have you attempted to introduce audio or video recordings into evidence that were made without, I presume that says, consent of the other party? What was the result? I have. So that was a very long time ago that I did that. In 2016 was the last time I did that. I will say courts strongly discourage recording without consent. Okay. The reason they strongly discourage it is because it's not all that reliable, because we don't know the context of what's happening. And so most often when you are introducing audio or video, the other person says, well, just before that, they did something to cause me to explode. So there's a lot of times where the court is not really that interested in hearing the audio and video because they don't know exactly what occurred before or after. Okay. The other thing that I would say about it is courts don't condone hiding recordings, and they don't really like that idea. In Canada, it's single party consent. So that means that it's not illegal to record. Okay. So you're not at risk of you're not at risk of that, but you are, there is a situation where the recording, it might be more harmful than helpful. I can go into it a little bit more in the Q&A at the end, but that's what I would say about that. It is kind of that contradicts a little bit of my other evidence where I say objective evidence is best. Pictures are very good. Courts really do like pictures of any sort of bruising, any sort of damage to property. Text messages are often relied on, but again, the context of those text messages is really important. A witness's testimony is evidence. So even when there's no documentary evidence or third-party evidence, it is possible that the witness's direct experience will be considered reliable and credible. What I always say to my clients is if you can include as much detail as possible, including dates, times, and specific facts, that always helps a judge be more comfortable that your evidence is credible and reliable. You have to be prepared for the defense of the victim made me do it. So in other words, I only act out when my ex-partner does something that makes me angry. And you have to make sure that you're connecting any relief you're seeking to the allegations of violence. I've also suggested that you consider direct evidence by affidavit. So again, when you're in court, there are different ways to present evidence. So one is testimony. So orally, somebody is answering questions just like I'm talking right now. The other is in writing. I almost always do my direct evidence in writing. The reason for that is that means that the victim doesn't have to recount their story orally to a judge. It can be a little bit less impactful because the judge isn't hearing you, but I usually find it's somewhat less traumatic for the victim, and a little bit less likely that they're going to forget details or not be able to give clear evidence. So I almost always suggest doing it in writing. But again, I would really point to whether there is some of the objective evidence, pictures or text messages to support that. Otherwise, I might want you to directly testify because it would be more impactful to the judge potentially to hear it. So that turns us to credibility. So this is almost always what a judge is going to be considering is, do I believe the victim? And do I not believe the perpetrators' suggestions that they didn't commit the offense? And so that's why I say that's almost always going to be the case. It's a he said, she said case most often. Occasionally there's third-party witnesses, but more often than not, it's just going to be what you say versus what they say. And so that's where possible, any sort of objective evidence you can have, any sort of pictures, any sort of text messages you might have, those will really be very helpful. The other thing that I always tell every single client is, do not fight with the opposing lawyer. So the opposing lawyer's job is to try to make you as uncomfortable as possible and to try to get you to change your evidence in any meaningful way that they can hang their hat on and say the judge shouldn't believe you. So the more that you argue and the more that you get into a back and forth, the more likely you are, firstly, to change your evidence, and secondly, to be less believed by the judge. And so that leads to the last point, which is to be consistent with your evidence. Try to make sure that the story that you tell is consistent all throughout. This is extremely challenging in domestic violence cases, and I realize that because I understand that a lot of people don't necessarily remember things as clearly, and their memories sort of open up over time. I understand that the details can change and shift a little bit, but the more that happens, the more that a judge is going to be less likely to believe you. And so the more consistent you can be in your evidence all the way through the case, the more likely it is to be accepted and believed. So when we talk about financial implications of family violence, most often I see an overlap between financial implications and parenting. So if there are parenting problems, there's almost always financial challenges. One of the most common is refusal to provide any or adequate child support. So there is a child support services now that will allow you to obtain child support without a court order. And so I'm hoping that might be one of the things that the center might be able to help or direct you to get some advice on, so that you can hopefully get child support flowing as quickly as possible. There's also often a refusal to provide financial disclosure, and that can include income tax returns. And so that was in existence in both Walsh and Hassler. There's usually a refusal to participate and pay for child-related costs, and the withholding of payment as a means of coercion and control. So often I'll see someone say, well, I'll pay you if you give me the parenting time that I'm asking for. If you don't, then I'm not going to provide any payment for the kids. Often there's withholding property that could include refusing to equally divide joint property, taking money from accounts and keeping it from the other party, or hiding assets altogether. So family violence cases can be extremely difficult because, in addition to the challenges that you're having with parenting, you also often don't have a lot of support or financial means to fight these kinds of cases. So that leads me to kind of the final comments and takeaways. Family violence cases are, I would say, some of the most difficult cases. And the reason they're difficult cases is because they're difficult to prove, as our Supreme Court noted. But in addition, even if you prove them, the question is, will you get a remedy? I always say to my clients, consider remedies and safety planning that do not require court and legal intervention. So I was glad to hear Joanne talk about that at the very beginning. I always recommend my clients go to resource centers to get safety plans in place, because no matter what a court decides, you need a plan for if somebody violates that order, or if you just need to have a plan for your safety, regardless of what any court's going to decide. So I always say planning for things that don't require court or legal intervention is very, very important. Consider whether the family violence exists, has a meaningful impact on the parenting plan that you're proposing, and if so, how. So I don't, even in cases where someone will tell me there is family violence, I don't raise it in court in every case, because I only raise it if I think that it has an impact on the parenting plan. The more that we raise the issue of family violence, the harder it is to negotiate, the harder it is to reach settlement proposals. Mostly because people become really entrenched into their position. So I would strongly recommend that you consider whether the violence is something that you need a remedy for. And if you don't need a court remedy for, I wouldn't necessarily raise it. I would also consider the impact a drawn out litigation dispute may have on increasing violence. So the statistics are very clear that after separation is your highest risk of a violent incident. And I would say that if litigation is ongoing, that risk probably does continue to increase. So you have to consider, again, the risk benefit analysis of what raising these allegations is going to do, and how it may impact your safety ongoing. I always encourage every victim of violence to engage in therapeutic help. And that's why resource centers like the one today are so important, because there's a lot of work that gets done outside of the court sphere. The court has very limited skill sets. It doesn't necessarily address all of the things that need to be addressed. And so making sure that you're getting that counseling and therapeutic help is very, very important. I would also say expect family violence cases to be extremely financially burdensome, as the cost to litigate is significant. So some of the cases are under legal aid. So if it's under legal aid, of course, that's less of a consideration. But if it's not a legal aid case, these cases can be, $50,000 to $60,000 to litigate. They're very, very, very difficult to litigate. And then you should always remember that proving violence does not equate to getting relief. And that remedies from the court do not always result in more safety or better parenting relationships. So I don't say that to discourage anybody, because I realize it sounds a little bit discouraging, but I say it to suggest that people come in with their eyes wide open and recognize what potential effects they might have when they raise these kinds of concerns. So that is everything from my presentation. Again, it's very dense, and I apologize for that. I know that there's a lot of things, and that it might be difficult to kind of grapple with them all. But I hope that it gave you a little bit of insight into the litigation process and what it might look like if you are to take a family violence case to court.